here we have Paul Calzada, and
Hello.
he's running to be in the 312 District Court, which is one of the family courts.
That's right.
And so Paul, tell them just a little bit about yourself. Full disclosure, I am donating to his campaign a whopping $10 a month because I totally support him, and I generally don't donate to campaigns. That's just my thing.
And thanks for that, Jen. So, my name is Paul Calzada. I'm a family lawyer here in Harris County. I was born in Houston. I've lived in Harris County almost my entire life. I moved out for a little bit in Austin, where I went to college. And then my wife and I, Maria Calzada, we moved to Fort Worth for a couple of years, and she went to physician assistant school there. Then we moved back here to the Houston area. I started law school. I went to the University of Houston Law Center, graduated in 2003, and I've been practicing in the Houston area ever since, and I've done family law primarily my entire legal career.
Okay, so I guess the first thing is that almost nobody knows what family law is about. And you know, until you have to actually walk into one of those courtrooms,
Right.
we don't even know why we're electing judges for them.
Sure. So family law is a kind of an umbrella term for any of the types of cases that would fall under the Texas Family Code. So that is the more obvious ones, which people think of: divorces, child custody. It also includes adoptions. It also includes the most, what we consider kind of like our most severe type of case, and those are parental termination cases where someone has asked the court to terminate the parental rights of a parent as if the child was not born to them. The opposite of that, we also do adoptions. And then we also hear things that are probably less common, habeas cases. So let's say someone has a legal right to a child. It could be a parent, or it could be someone that has a custody order and they have legal right to have possession of the child, and someone else is keeping that child from them. And if you want a court to make an order that they have to return the child, and actually you can get law enforcement involved, you would file a habeas or a writ of attachment, and that would go to family law court.
Okay. That's pretty rough stuff. I mean, one of it's what do I say? So I update periodically who the justices are. So, for example, this is a printout of everyone that I can vote for on the Referee Pack website, and there are, I don't know, 130 judges in here or something like that. And the family court judges, I don't always see the same people coming up and running for office for those as I've seen for the other offices. So it seems like there's a little bit more turnover in those. And I was wondering if you had any thoughts on that.
Sure. So lately, we did have turnover. So there are 10 primary family law courts in Harris County, and 9 of those courts are up for election at the same time, on the same cycle. Family law judges, they're district court judges, so it's a state court, even though their district is Harris County. And all 10 of those courts are cover Harris County. 9 of them are on the same cycle. And so the outlier is the 507th, which we just had an election 2 years ago and won't have one for another 2 years. All the rest are up for election this year in 2022. So what happened in Harris County was the last cycle was a sweep. So we had all new judges in every court. And so that was probably the biggest turnover you could have, because we had all new judges in every court. Prior to that, the judges, I think we had a few judges that had served for multiple terms, but we had a lot of judges that were only in their second term or first term. So I would say in the last 3 election cycles, we have had pretty high turnover in the family law courts.
Relative to the courts, one of the things that I kind of wondered is, what do I say? What kind of background experience do you have to have in order to be a judge in one of these courts?
Sure. So if you want to be a district court judge, you have there's laws in Texas that determine minimum eligibility. So in fact, we just had a vote on that where we upped the years of practice you have to have. So it was 5 years of practice, and now it's 10, or it's going to be 10, not for this election. You have to be a lawyer in good standing with the state bar, and there's actually an age requirement. So you can actually age out of being a state district court judge. You're no longer eligible to run for election after you've turned 75. So you can get elected. You can be 75. You can turn 75 while you're on the bench, but you have to finish out that term, and you can't stay on the bench any longer.
Oh, that's interesting.
Now, there are a few other little requirements, but something I like to point out to people is there's no requirement that you primarily practice in the area of law for the court that you're trying to get elected to.
That's what I was wondering. So if we're talking the family code, if I come in and I'm familiar with the engineering code, then that wouldn't make me necessarily qualified to be a judge, but relative to the law, I could still, if I was a lawyer, then I could still say, hey, I want to be a judge in this court.
Right. And so to take it to the extreme, you could be a lawyer, you could have 6 years of practice in good standing with the bar, and you could have never set foot in court, and you could run for a trial court bench, and there's nothing preventing you from doing that other than convincing the voters that they should vote for you. Take it a little more realistically, it's entirely possible that you could run for, let's say, a criminal court bench, and you've never practiced criminal law or never had a criminal trial. Same thing with family law. You could take the occasional divorce case and think that you know enough about family law to be a judge. You can run for a family law court. There's no prohibition on you doing that.
Okay. So there was something that you said relative to the qualifications that I was thinking more about, but I just lost my train of thought.
Maybe it'll come back to you.
It'll come back to me. Okay. Oh, one of the things that I was wondering is, let's say that, so I'm going to tell you a story. Whenever I was taking one of my OSHA classes, the instructor said, hey, let me tell you a story. And what it was that a young woman who he barely knew was a neighbor with him at some point in time, and they lived in some county way off in the middle of nowhere, and I can't even remember the name right now. Maybe it was Como County or something like that. And then she moved to Harris County, and then she died in a car accident, and the babysitter was sitting there going, what do I do with the kid that I've been watching? And so the only person that they could find on her cell phone was his contact information. And so they said, she's got nobody, and would you be interested in, taking care of the kid? And so his wife, having a very big heart, said, yeah, let's do that. And then after a period of time, they decided to adopt the kid, and part of it was that they had to go find the father and all of this kind of stuff. And so they got into Como County Court, and they're like, okay, we're ready to adopt the kid. And they said, well, we don't have jurisdiction. This should be in Harris County Court because that's where the kid started. Right. And I was just like, what's going on with this story? That's crazy town.
Yeah. So so you have two geographic issues that you typically deal with in a family law. So jurisdiction is kind of what is the best court, the proper court for you to be in. And then we have a subset, which is venue. Which court out of all of the courts in that jurisdiction is your case going to be set? So it sounds like in this issue there was in a different county. The home county was probably Harris County for that child. And so there's probably a couple of factors going on. One, that court may want a court that is in the county, the venue of where the child is, maybe for reasons of if there's anyone else that may know that child, or if there's there's any other possibility that that kid has, that's where their pediatrician is. If they were in school, that's what their school would be. So there's always that concern that you kind of want the case to be in an area where that child has, that's where their reach is, right? I don't know if this was the case in yours, but anecdotally, sometimes venue can be proper in more than one place. And sometimes the courts, in a difficult type of case, maybe they don't want to deal with it, or maybe they were in a small county that doesn't have specific family law courts, and that judge may have felt more comfortable sending it to Harris County, where we have specialty courts for family law. That's something we didn't really mention earlier, but just as an aside, Harris County is a very big county. We have lots of people. So our courts are actually specialized. So in many counties, you don't necessarily have family law courts. You just have civil courts of general jurisdiction. And they'll have everything from a car wreck to an adoption. And those judges, I would guess, my experience, I've done this about 18 years and going out to the small counties, most of those judges are not family law attorneys. So family law is kind of the not the main thing of what they've done in their practice and what they do in their courts. It's entirely possible that judge may have thought that case would have been better served in a specialty family law court in Harris County.
How interesting. Okay, so I'm just going to jump over into like the political spectrum, but I didn't want to jump too far.
Sure.
And one of the things that so frankly, I've always thought that judges should be a nonpartisan office. And one of the things that I find disturbing is that in a number of areas you will have elections where there's nobody running against the person on the November ballot. So the only opportunity that you had in order to select somebody for that position was on the primary ballot. And so I just wondered, you mentioned that you had a few thoughts on that, just, light brushstrokes. What do you think about that?
So it's kind of starting off at the top, right? Not all states elect their judges, or at least not all of their judges. In many jurisdictions, it's by appointment by the executive. So think of county commissioners, or think the governor would appoint judges. In Texas, we don't do it that way. We elect our judges. And I've been on the campaign trail for a few months now, and it's kind of funny to hear candidates and judges talk about that. And the consensus always seems to be, somewhat jokingly, is electing our judges in partisan elections is the worst way to do it, except for all the other ways to do it. And so the reality becomes, you're right. You have candidates who want to be judge, who meet the qualifications. They're going to run in a partisan race. So my race is I'm in the Democratic primary, and there are actually 3 candidates for my court, and there's a Republican primary. To the best of my knowledge, there's only 1 candidate. So the Republicans already know who's going to run in November for the 312th. We don't know yet. We won't know until after March 1st when the election is.
Hear that? March 1st is the election, so you want to make sure to look at your ballot and early voting and research. Okay, sorry.
Yes, no, very good advice. And so the reality is we're probably, in Harris County, it kind of swings between the parties. So the Republican Party was kind of the dominant party for a while, up until very recently. And very recently we had a Democratic sweep. And so ostensibly the Democratic Party is kind of the party in power right now. Obviously, anything can happen in an election. We don't know. But the reality is, in a lot of these races, the primary is going to determine who ends up becoming the judge in that court. And the primary votes are much smaller in number than the general election. I looked up some stats in the last few primaries in Harris County on the Democratic side, and it's anywhere from 160 or 70,000 voters to maybe up to about 300,000 voters. And not all of them vote in the judicial races. So if you guys look at your ballots, you'll see that there's a lot of offices you're voting for in the district courts, in the county courts, and the JP courts. Those are all at the end of the ballot. And frankly, a lot of people just don't get that far down. And so if you have 300,000 votes in the Democratic primary, you may actually only have 200,000 votes for the district court judges.
Yeah. It's and the county's so big. I don't remember exactly how many people we have in the county, but It's what, 3 million maybe?
Yeah, I think it's 3-4 million.
It's
We're
up
pretty
there.
big. Yes.
And so, to have, just a fraction of that is incredibly, I don't know. It just seems like the design is not the best if you have such a small minority that decides everything. But our turnout usually is less than 50% anyway, so I don't know.
Yes, and I looked up. So if you go to harrisvotes.org, you can get a lot of the information. We're looking at around 20% in
Yeah.
a lot of these elections,
Yeah.
25%. And as a family law court candidate, I like to tell people, you may not ever be in a court at all in your entire life. It's entirely possible, maybe traffic court. But if you are going to be in one, for most people, the odds are it's going to be a family law court.
Wow.
Now, if you're picking judges and they're in elections and only 15 to 20% of the people are voting, that means you're going to go in front of a judge who was selected by a very small percentage of the eligible voters in that county. And so I always tell people, please make your way all the way down the ballot. Please get down to all of those courts and please research them. There's a lot of clubs. There's organizations like Referee Pack. There's local political clubs. There's a League of Women Voters who put out information.
Yeah. Really good.
And
yeah.
And so please look up some of these judges, look at their experience, see what they are offering as their credentials, and try to vote accordingly.
Does the state bar still put out kind of I don't know, put out just kind of a survey that they did of the candidates and how they ranked among other lawyers, but that always seemed kind of fuzzy to me.
Yeah, so we don't. I'm not real aware of any that does that on the state district court level. Mm-hmm. You do have some organizations that'll do it for the appeals court, for the Supreme Court, and then in the federal courts.
Okay.
We don't really have, you don't get a grade from, the American Bar Association like they do for federal appointments. What we do have is we have an endorsement process, and those are done not by the state bar, but done by various political groups and political clubs. The Houston Chronicle also does one, right?
Yeah, and the Chronicle.
And then, of course, as an attorney, you have board certification, which, you can have board certification, and then you also have the Texas Bar College, which is, it's not certification, but it's the only other state bar designation you can put on your materials as an attorney. And the State Bar College is, I'm a member of that, and it's basically you have attended significantly more continuing legal education classes than are required by the bar.
Okay.
And so you have to keep that up every year.
Oh, fantastic.
So they're amongst the more highly educated of the attorneys practicing.
Okay, so what is that you're supposed to look for on an attorney? It's the State Bar College?
Sure, yes. They're a member of the State Bar College, and then any certifications.
Okay, so look for that. State Bar College and any certifications. Relative to the family courts and the size of the county, what is the kind of I guess caseload that
Sure. Yeah.
There are 10 courts, right?
Yes.
So what kind of load are they dealing with?
So at any time they can have a couple of thousand active cases. Family law is a family law case is different than, let's say, a civil or a criminal case in the sense that a criminal case, right? First of all, you have a right to a speedy trial. So there are certain mechanisms to help you get from the charge to the trial. Mm-hmm. Civil litigation, there's typically high motivation to get that done, right? You're trying to either get injunctions for someone to stop something, or you're looking for a cash reward. Family law, yes, there's a sense of urgency, but a lot of times those cases can linger. Right, so you have two people. They're trying to split their lives up. They're trying to split their finances. So the courts and family law are very sensitive to how long those cases are lasting. Mm-hmm. They try to get you set for trial within a year. Mm-hmm. They'll let you do it shorter if you have agreements or it's an uncontested case. And I know the judges pay very close attention to that, but it's not uncommon for them to have a couple of thousand cases active, and that means at one time. In the course of the 4 years on the bench, it could be significantly more than 4 times 2,000.
That's a lot of issues to deal with, really. So I know a lot of people that have been on civil juries or criminal juries, but I don't know anyone that's ever been on a family law jury. So
Okay.
is that the same jury pool, or is that something different?
So it's the same jury pool, but family law is there are only certain issues that you can take to a jury. So unlike, let's say, a criminal case where you can try your case to the bench or to the jury, it doesn't matter at all what kind of issue you have. And any criminal law attorneys will maybe take exception with me being global about it. But generally, you're either you can get a jury trial or a bench trial, or you're going to plead it out. Family law, we don't take all of our issues to a jury. The state law, the family code, doesn't allow you to. So you may be able to take an issue such as characterization of property to a jury, but you wouldn't be able to, let's say, take an issue of division of that property. Mm-hmm. Or you may be able to take conservatorship of a child to a jury, but you wouldn't be able to take possession and access to a jury. So the reality is, in family law, we have significantly less jury trials simply because most of our issues aren't tried by a jury, by law. Also, too, in family law, it's a little different in the sense that you're dealing with someone's family, their livelihood, their everything they've built during their marriage and their children, and there is a very strong preference for people to be able to resolve those without having to go to court. So in family law, we do mediation very often. In fact, in every court I'm aware of in Harris County, it's required to mediate even for temporary orders before you have a hearing before the judge. And then even if you have an agreement or not in temporary orders, you will frequently have to go back to mediation. Maybe not the same mediator, but sometimes it is, for all of the issues on final. And the courts really want people to have an opportunity to settle their family law case. And I tell my clients this all the time. You know your situation and your spouse's situation better than anyone else. And you definitely know it better than some judge who's maybe going to hear you for 2 or 3 hours, maybe 2 or 3 days in a really big trial. It could go longer, but sometimes they're shorter. And then you're asking that judge to make profound decisions on your family and how often you're going to see your children and what property you're going to keep and what your visitation is. And so there's a strong preference that we help our clients work it out in a mediation process or negotiation process. And so we successfully do that, I would say 70-80% of the time. Mm-hmm. So you simply don't go to trial as often in family law, and then even when you do, you don't go to jury trial as often.
Okay. Schedule. So, how are we doing on time? Or we just gotta. We'll wrap up the conversation. But I was wondering about a daily schedule that a judge deals with.
Sure. So, there may be some things that the judges do that I'm not aware of since I'm not there, and I'm sure every judge is different. But judges typically, they come in the courthouse. The ones I know are usually there by 8 a.m. Docket calls usually at 9. So they're going to come in early. They're going to look at their docket. They're going to get the administrative tasks taken care of, right? They'll usually have their coordinator or their clerk print out a docket for them. There may be some early morning prove-ups. So uncontested cases, those people usually show up around 8:30 or so, and they get a quick prove-up in front of either the presiding judge or the associate judge. And then typically docket call is at 9 a.m. And before COVID, the way docket call worked is all of us who had cases that day all showed up to the courthouse, and we went into that courtroom and we sat down,
breathed each other's breath.
Yeah, and it's funny because that we got to see each other pretty much every day, because even though Harris County is a very large county, the family law bar is it's small. I mean, you kind of see the same people every day at the courthouse, and that's where all my friends were. So we'd show up, we'd chit chat, and we talk. Sometimes we talk to opposing counsel, because the opposing counsel. Yeah. And then the judge will come out and go through the docket, read the docket, and then you'll announce that you're there, who you represent, what you're there for, and how long you think it'll take. And if you have ever sat through a family law docket and you start adding up all the time that the attorneys say they think it'll take, it will come up to oftentimes hundreds of hours.
Right.
And as you're well aware, we don't have hundreds of hours in our day. So what the judges will then do is the judges will start putting you in rank order, triaging you, right? So the simple, easy things that aren't going to take very long, they'll usually take those first just to get them out of the way so you're not sitting around. Those that they know are going to take a couple of hours or so, they may tell you to come back in the afternoon, right? I'm going to send preface you for the afternoon. A lot of people are going to get reset to another day that they're not going to go in front of the judge at all that day. And the judges will typically, at the end of docket, after we've all heard what's going on, will encourage us to go out into the hallways and get to work. And what that means is take your client out in the hallway, have your opposing counsel at the client in the hallway, split them up, right? Have one at the far end and the other there. And then the attorneys go back and forth and see what they can work out, if anything, in that particular case. Typically on temporary orders, motions to compel, those types of things. Now, final trial, really, you've probably worked it up as much as you can and gotten the agreements that you can before you show up. So a lot of the temporary order hearings, they'll encourage you to try to work them out. In fact, I don't know if they still have them, but before COVID, they had forms that you would go grab from the clerks of the court, or they had these little banks, with all the little forms. And one of the forms was an agreed temporary orders form. And I've probably filled out hundreds and hundreds and hundreds of those over the 18 years I've practiced, because the reality is the clients want something that day.
Yeah,
they're simply not going to
and
then drive downtown. There's simply not enough time for the court to hear hear those temporary orders hearings, and so you encourage them to get it worked out. And sometimes you do a Band-Aid order, which is an interim order, so it's not really an order of the court in the sense that you presented evidence. It's kind of a, let's just maintain the status quo, get a few things done, and we're going to come back in a month, and we're going to have a hearing, or maybe we have to go out to mediation. Now, post-COVID, or I guess we're still during COVID, a lot of the hearings are Zoom. And so there's really not the same type of opportunity to get together and hash out an agreement. So what of a lot of attorneys that practice family law primarily like us, is we try to work a lot of that out before the hearing day, period. And in fact, we're pretty much all going to mediation. Really like that. They don't have to go downtown.
Yeah.
They don't have to pay for their attorney to sit there and wait for 5 other cases to go before they get to go. They don't have to face their ex or soon-to-be ex, which can be very traumatic for a lot of people. And they can have a Zoom hearing from the comfort of their home, or, a lot of people are at work. They go sit out in their car, and, we're able to get things worked out. When I said Zoom hearing, I meant we can do a Zoom mediation, and they can get things worked out, and they don't have to go to court. And a lot of people really have enjoyed that, I've noticed.
Okay, so final question. Okay, how is it perceived if you end up having a judge's decision appealed, and then the appeal is the decision?
I've talked to them about it, and I have friends who are judges. Of course, they never like it. I've rarely talked to a judge that was happy that they were reversed on appeal. But the reality is there's a couple of reasons why you have to take a judgment to the appeals court, or an order. Sometimes you just think the judge got it wrong. Sometimes you think the judge either saw the facts differently, and the facts were overwhelming, and the judge just got it wrong. Sometimes, especially on final trial, there's error, right? Maybe they let some evidence in that shouldn't have been let in, or they kept some evidence out that should have come in, and let's say you have to do an offer of proof, and so the appeals court looks at it and says, yeah, we think that should have come in, and so maybe the jury should have heard it, or maybe the judge should have considered it. And sometimes, and I'm not going to name any names, but I've talked to judges, and we talk about, my friends that are judges, we talk about stuff. Sometimes they are just not going to make the order that sometimes both of the attorneys want, or that the parties want, and they just don't think the order is either just and right in a property division, or in the best interest of the child, even though everyone agrees. And the judge may say, I'm not going to sign it, and this is the order I'm going to sign, and if you want to appeal me and you want to get the appeals court to tell me I have to sign that order, or tell me I have to consider it, I'll do that. But But family courts are courts of equity. That means that the judge is given an extremely wide latitude to make orders that they believe are, in the phrases we like to use, are just and right division of property or in the best interest of the child. Mm-hmm. And there's no strict definition of what best interest of the child is. It's really dependent on the judge, which is why...
It sounds very organic.
Yes, and which is why I think it's very important that family law judges be family law attorneys, mm-hmm. because we will draw from, hopefully, a wealth of information and experience when we make our decisions. And if you've seen 50 family law cases, you really can only draw let's say you've seen 50 cases in the last 20 years. You're really only able to draw from the experiences of those 50 cases, as opposed to an attorney who's seen 200, 300, 400 cases, and every case is different, and they're able to draw from a much broader base of experience and see how people have done things and see what other attorneys have brought up and what those judges have done, because court orders in family law court have to be nuanced. They have to take into a lot of concern about the parties and the situation. It's not just cold hard facts. Was this person in this place at this time, like a criminal case? Were they there? Did they do the act? Or a civil case, right? Was the light red when the truck went through the intersection? There's
a lot of psychology in here.
Family law is completely different.
Yeah.
In fact, I have this whole idea that I like to talk to people about when I go around, about how family law is not a zero-sum game. Criminal law, and again, criminal bar is probably going to take this section, but criminal law typically, to most people, is you're either going to be incarcerated or you're going to be free, right? And every day you're incarcerated is a day you're not free. Mm-hmm. And every day you're free is a day you're not incarcerated. It's zero sum. Mm-hmm. Okay? Civil litigation is very similar. You're either going to pay that $1 million or you're not going to get to pay it, or you're going to get the $1 million and you're not going to get it. It's kind of a zero-sum game. Family law is not like that. Mm-hmm. Family law, it is entirely possible that a good judge, who has lots of family law experience and can see all of the angles and make a nuanced, crafted order, can actually raise the lot for all the parties in front of them. It doesn't have to be, if I raise you, I have to lower you, right? Mm-hmm. We can actually make an order that's better for everyone. The awesome responsibility, though, is that if you have a judge that doesn't have a lot of family law experience, or who doesn't have good temperament and doesn't let in the right evidence, or doesn't let people present the case the way that they should be able to, you can actually make an order that's worse for everyone. Mm-hmm. Right?
Yeah.
And so it's a different beast. Mm-hmm. And I think that's why a lot of attorneys won't touch family law. And I think the people who dabble in family law, the dabblers, as I like to call them, they don't really appreciate the full depth of experience and knowledge that family law requires.
Well, I feel like I know a little bit more of the unknowns, but I still know that I don't know a lot of stuff that I don't know.
Gotcha.
Rumsfeld said that. Yeah. Okay, so this is Paul Calzada running in the Democratic primary for Court 312, and I will link all of his information. And if you have any more questions, please send them to info@refpac.org. But you will also be able to visit his website, and you can ask him through his email. What's your email?
It's paul@paulforjudge.com. And if you go to my webpage, you can also send me a message, and that's Paul for Judge, FOUR, paulforjudge.com.
Yeah, if you send the email to me, I will probably rephrase your question and then forward it on to Paul. So,
and I look forward to any questions that anyone may have.
All right. Well, thank you. Thank you so much.
Yeah, it was a pleasure.
And we're signing off from Old Town Spring.
Bye, everyone.